I'm Susan Moon, Executive Director of the Walnut Creek Library Foundation, and I'd like to welcome you to the second of our Finance 102 programs, Trust and Estate Planning in Today's Environment. I'd like to thank our masterpiece sponsors, Kathy and Jerry Hicks, as well as our media and print sponsors, Diablo Magazine, East Bay Times, and Minuteman Press Lafayette. I'm pleased to welcome tonight's presenter, Joan Grimes, a local attorney here in Walnut Creek. Joan has over 30 years experience as an attorney. She has served as the president of the Northern California Bankruptcy Forum and also as the chair of the Contra Costa Commercial Law and Bankruptcy Section. Joan graduated from the University of California, Berkeley, and was awarded her JD from California Western University. Tonight, she will provide a review of estate planning, as well as what's new this year with information on Prop 19 and how proposed changes to the tax code may affect your estate plan. Following her presentation, we will have a brief Q&A, and you can submit your questions in the Q&A box below at any time. If you enjoyed tonight's program, please consider making a donation to the Library Foundation to support our programs. Visit our website, wclibrary.org, or click on the link located in the chat box to donate. Now, please welcome Joan Grimes.
Thank you, Susan, and thank you, Kathleen, for having me today. I'm going to share my screen with you. And here we are. I just need to be able to see it a little bit better. So thank you so much for having me here tonight. I am Joan Grimes, and my offices are here in Walnut Creek, and I have an office out in Brentwood. We are going to be talking about trust and estate planning in today's environment. Before I get started, I just need to say that the information I'm providing tonight is for general information about estate planning and different options available to you in the planning process. This information should not be relied upon for making specific decisions about your estate plan. Before making any decisions about your estate plan, you should seek legal counsel to ensure you are making the correct decisions based upon your specific situation. And I'm going to set my timer here and start it at 45 minutes. And then when I'm done, we will take questions. So estate planning, I've got to move this here so I can see what my screen says. So your estate plan. So estate planning is the process of getting organized and creating a plan for your loved ones. The benefits of doing a revocable living trust is that you're able to maximize the enjoyment of your assets during your life, and to create a plan so that if you become incapacitated prior to death, you have a plan so that we have somebody who's in charge and how your assets are to be used during this period of incapacity. It also then provides an orderly distribution of your assets after death. So really, a trust has two functions. It has the function of helping take care of you if you become incapacitated. And then second, it disposes of your assets after your death. Okay. The consequences of failing to establish a revocable living trust is intestacy as the default estate plan. So the state of California, you don't have to worry, the state of California has an estate plan for you. You may not like it. It involves probate. It involves your assets simply going to your family or your spouse or some combination depending on your situation, but they have a plan for you, but it's their plan. So we really encourage you to make your plan. If you don't have a trust and you become incapacitated before you die, in most cases, you will have a conservatorship, which is court supervision during incapacity. And in most cases, it involves at least one attorney for you, the conservatee, and it may involve another attorney for the conservator, the person who is actually taking care of you. It is a very long, expensive process, and we really encourage people not to do it. It's sort of, I tell people, it's sort of like family law. No one likes it. And if you don't have a trust, after you die, you will have a probate, unless your assets are very small. In this case, they're under $166,250. All right, so then let's go to our next screen. I think I moved mine too far down, and therefore I couldn't. Nope. There, next. So your tool belt, your estate planning tool belt, an estate plan should include the following documents. It should include your revocable living trust. It should still include a will, but now instead of giving you a testamentary will, so let's remember a testamentary will is like the old wills we used to have in the old days, where it simply said, I, Joan, give everything to Tom, my husband. If Tom dies, he gives everything to me. This will is called a pour-over will. It's a technical will, and it says if there's anything left at the end of the day, it goes back up into this trust. It pours over into this revocable living trust, and then the assets are going to be distributed in accordance with the terms of this trust. Now, if you become incapacitated before you die, we still are going to need you to have a durable power of attorney, sometimes called a statutory power of attorney. This document is used for assets that are not in your trust. So let's think for a second. What are assets that would not go into your trust? Typically, it's an IRA, a 401k, an annuity, but it's something that someone might need to access on your behalf if you were incapacitated. Then you have your healthcare documents, your healthcare directive, you have your HIPAA. If you have a chronic illness, we may have you also do a POLST form and help you fill that out so you can take it to your doctor. We then assign your real and personal property into the trust. You have a certificate of trust, and you can also have a living will. So a living will also, once again, just reinforces the terms of the healthcare directive. But that's very important, especially if people are really, they really want to make sure that people understand that they don't want to be on life support if they're in irreversible or terminal condition. So one of the things sort of when we're thinking about these trusts is that you can spend, money and you have the documents drafted, but if you don't fund your trust, it's pretty much doesn't help. So your estate plan is only as effective as its implementation. Now that you have a trust, that you've drafted the trust, don't forget to put your belongings in it. So the things we want to make sure go into your trust is any real property, and we want to make sure bank and brokerage accounts go into them. So what you want to do is, if you're making notes here tonight, is to make a note to check your bank and your brokerage accounts to make sure that it shows the name of your trust at the top. If it does not show the name of your trust at the top, you should go down to the bank or to the brokerage or call them, and you want to get those accounts in. Recently, we've been finding quite a few people who have been buying CDs through either Capital One or Discover or American Express, and those accounts have not been put into the trust. If you're going to open one of those accounts and buy CDs, because they advertise at night on TV, I'm convinced that's what's happening. And they're also offering a little bit better rate. So in fairness, they're offering a little bit better rate than the banks are at the moment. You want to make sure they go into the trust. Okay. So if your house is not in your box, you're going to have a probate. If your bank and your brokerage accounts are not in your trust, you need to make sure, if they're not in your trust, you need to make sure that you have a beneficiary designation on them, or they will go into the probate. But let's think for a minute. We really don't want them to have beneficiary designations. And the reason we don't want them to have beneficiary designations is that if you just keep your name on the account and you become incapacitated, how is your agent going to access those accounts? Now, in the old days, you would probably say to me, oh, they'll use the power of attorney. That's what I used with my mother. And that's true that in the old days, you could use your power of attorney to access bank accounts and brokerage accounts. That is not the case anymore. Today, in most cases, the banks will not allow you to use a statutory power of attorney because they have actually become reporters of elder abuse. So when a child goes into the bank or goes into the brokerage and tries to use that account, they usually say, no, go get a conservatorship. So to avoid that, you want to make sure that that child is in fact your successor trustee. So if you become incapacitated, the accounts will be in the box, will be in the trust, and they will be able to access them on your behalf. So let's just go over funding for a couple more minutes. So funding steps. You establish your trust. You analyze each of your assets. You consider whether each asset should be transferred to your revocable living trust. And we encourage you to review each of your assets with an attorney to make sure you're doing it properly. Most attorneys who do estate planning all the time are going to also do the funding for you, okay? And if there's anything that I really encourage you to spend a little money on is to pay someone to help you with the funding, because funding is a lot of work. That's one of the reasons it's cheaper to go to attorneys who don't do funding, because doing funding is work. But if you don't fund your trust isn't really going to be helpful. It's going to be very hard for your people to use it. So we want you to obtain the documents necessary to transfer the assets, and then we want you to transfer title, and we want you to periodically review to make sure your assets are in fact in the trust. So this today would be a very good day to do that. Okay, but for a moment, let's also talk about disposition of non-trust assets. So trust assets are distributed in accordance with the terms of your revocable living trust. What happens to non-trust assets? Accounts that have beneficiaries listed will be distributed by the financial institution to the named beneficiaries. It is essential that you periodically review your beneficiary designation forms. Financial institutions are known to either misplace your designation, or the more common example is that their software is updated and they lose your beneficiary designations. So I really encourage you at least once a year to go in and make sure you have beneficiary designations. Most of the large custodians, Fidelity, Vanguard, Schwab, Bank of America, you can all do that simply online, but you can also call them too, but online you can do it. Now, there are a couple of things that we call will substitutes. So instead of doing a will or having a trust, you can do something that substitutes for that. And that is joint tenancy or community property with the right of survivorship. And then that asset will be distributed to the survivor. So it's common for the most common is between a husband and wife, and they hold title. If it's not in a trust, they hold title as community property with the right of survivorship. And that means that the property goes to the survivor. The problem is if they don't then put it into a trust, what's going to happen after the survivor dies? Now, the same thing is with joint tenancy. If you have joint tenancy with the right of survivorship, then the survivor takes all. It is very important if you have title as joint tenants that you make sure it says joint tenants with the right of survivorship. There's also co-owning of bank accounts, and then the survivor takes all. Many a parent comes in here and tells me that they want to put one of their children on their bank account so the child will be able to have access to the account if they become incapacitated or after they die. If there's not a lot of money in that account, it's okay with me. Where there really becomes a problem is when there's tens of thousands or hundreds of thousands in an account, and they put one child on the account, and then after the death, the child says, well, it's mine. And then the other children say, no, 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 no. You know, that was really our mom's, and that was really supposed to be divided between us. That is just ripe for litigation. So we really encourage people, instead of putting their children on the trust, that they put the trust account in the trust, they put the bank account in the trust, and then name the child to be the successor trustee in the event of incapacity. That's a much better thing to do. Less problems afterwards. So your comprehensive estate plan. When you are reviewing your estate plan, review the terms of the revocable living trust and each of the assets. So when you're thinking about reviewing your estate plan, you want to see who are your beneficiaries, who is your trustee. If you're married and you have a trust that was done before 2012, you want to see if that trust still has a mandatory split provision, which says after the death of the first person, the trust needs to be split in two. If it does, you really want to see a lawyer and see if having that provision is still necessary for your particular situation, okay? And once again, was the assets properly transferred to the revocable living trust? You want to check your grant deed to make sure it's in the trust. You want to check your bank and brokerage accounts statements to make sure they're in the trust. If you have lots of US savings bonds, please help yourself and help your children by getting them registered with Treasury Direct, okay? And if you can't do that yourself, please ask one of your children to help you, because it will be infinitely easier for everyone when they need to cash the bonds if it's registered with Treasury Direct. It is very difficult to handle outside of a trust, and if they are not registered with Treasury Direct. It's just lawyers make money having to take care of these. And to be honest, it's not an easy way to make money. And I would much rather see people get them registered with Treasury Direct so that it can be just sold after the death of the surviving spouse. Then you want to review your non-trust assets, retirement accounts. Check that beneficiary designation form at least once a year. All right, so you know, the big question of the day is taxes and estate planning. And the tax reform, which is coming to us very shortly here, is going to change in many ways the way that we currently handle taxes in estate planning. And as we go along here, I'm going to talk about the changes that appear to be in, so as many of you probably know, there have been 4 bills that have been going through the Congress. It appears one is through appropriations and is now working its way over to the Senate. So I think it's the one we're going to see, but we don't know. You know, it's like making sausage. Until it's actually signed, we will not know what it's going to do. But I'll give you the best guess based upon the information I have today. So when we're looking at taxes, we're really looking at taxes in estate planning. We're really looking at several different forms of taxes. So we're looking at estate taxes, we're looking at gift tax, we're looking at income tax, we're looking at capital gains tax, and we're looking at real property tax. Those are really, and I could do another whole course just on probably any one of these 5 things, but I'm going to just kind of go through them and highlight the areas that you, or the issues you should be aware of. So the federal estate tax is a tax on the estate of the decedent. It is not a tax on the recipient. Lots of people ask me that. It's a tax on the decedent. The rationale of the estate tax was to avoid double taxation, i.e., if an estate had to sell property to pay the estate tax, the government did not want the estate to pay capital gains on the sale of the real property and then estate tax on the remainder. To prevent this inequity, the government permitted a step up in basis to fair market value for all assets included in the decedent's taxable estate for estate tax purposes. So one of the questions has been asked is the step up in basis going to remain? As we sit here today, it looks like the step up in basis will remain intact. As a practical matter, it would be very hard for them to get rid of the step up in basis. Most people, if they've owned properties for a long time, have no idea what they bought them for. They have no idea the work that's been done on them. It would just be a nightmare for the IRS. So I think as we sit here today, we believe the step up in basis is going to remain. So the history of the estate tax exemption. So the estate tax exemption is once again a tax on the transfer of wealth from one generation to the next, i.e. a death tax. The estate tax exemption amount has fluctuated greatly over the years. So just taking the last 20 years, in 2000, it was $675,000. 2002, it was $1 million. In 2017, it was 5.9 million. And then in 2019, it went up to 11.4 million. And this year in 2021, we are sitting at 11.7. When I did this slide last week, we expected the 11.7, which has a kind of a COLA provision, a cost of living attached to that. We expected that to sunset and return to approximately 6.2 million in 2026. Okay, so January 1st of 2026. However, the bill that is in the hopper right now that seems to be gaining strength is going to make the sunset not January 1st of 2025, but January 1st of 2022. So that means that starting January 1st of 2022, the exemption will go back down to roughly 6.2 million per person with a COLA still on it. That will mean for a married couple, it will be, assuming portability is done, it will be 12.4 million. What this is really going to mean is that there are a lot of people that are going to have to file a 706 estate return after the death of the first person to be able to carry over the unused exemption from the decedent to the survivor. So that's where it sits right now. Now, one of the questions that people ask all the time is, should we maybe keep those mandatory AB trusts, or what were the old ABC trusts, because the exemption is going to go down? And so let's just, for people who aren't familiar with this lingo, let's just talk about it for a second. So what is an AB or an ABC trust? Upon the death of the first spouse, it's a trust that is divided into 2 or 3 sub-trusts. And why did we use these AB trusts? And we used them all the time before 2012. The number one reason was because we wanted to be able to double up on the exemption. So we wanted to double up on the 6.2 million, or before that, the 675,000. And we didn't, at that point, we didn't have what we have today, which is portability. Portability allows us to file a 706 estate return after the death of the first person. And to the extent the decedent didn't use his exemption, we can then tack it on to the survivors. So here, let's just use an example. Did I have here? Let me see if I put an example here. No, I really didn't. Let's go back here. Let's see if I can go back. We didn't have an example, but let me just tell you one. So imagine you have, let's say you have a $10 million estate. Okay. At the time the first person dies, you have a $10 million estate. It's all community property. So each person gets $5 million. So the deceased person gets 5 million, the survivor gets 5 million. Now, but your exemption is actually worth 6.2 million. So to the extent that you didn't use your exemption because you had to use 5 because your estate was worth 5, the deceased person's 5, there's still $1.2 million left, assuming that was the exemption, 6.2 per person. So to the extent you don't use your exemption, you can give it to the survivor. That 1.2 million, you can give it over to the survivor. And that was the big reason that we did the mandatory split trust, was because we wanted to double up. And we needed to double up because we didn't have an ability to do portability, to basically move the coupon over without doing this split of trust. Well, now, since we have portability, we don't need to do this split of trust. But there are still reasons that people do the split trust. The number one reason that people do the split trust is that they have a blended family. So you have 2 people who each had 2 children who came from a prior marriage, and they want to make sure that when the first person dies, that everything just doesn't go to the survivor, and the survivor then leaves it to their 2 children instead of splitting it among the 4. So that is the goal. It's not perfect. It has, AB trusts have all kinds of issues, and protection of beneficiaries is mediocre at best, but it's one of the reasons we use them. People also use the AB trust to guard against undue influence or elder abuse, especially if they have children or beneficiaries that have drug issues or mental health problems. We see those AB trusts used a lot. But the big reason we used them before was for tax savings, and we really don't need them anymore for the tax savings reason. All right, so let's go back and let me just show you for a second of how this ABC worked. So here we have our revocable living trust. And then after the death, here's the first death right here. And we have the survivors. So they get the survivor share 1/2. And then we do a bypass trust up to the exclusion amount. So that's 1/2. So each of these is equal. But if the exclusion amount went way down, say it went to 3 million and you had 5 million in assets, then you'd put your 3 million here and you'd throw the rest over here into this marital trust. And then after the second death, it all comes down into this residue. And these trusts usually have their own beneficiaries, but sometimes they all have the same beneficiaries. It just kind of depends on what people want. So the important things to know about if you do a bypass trust is that it's irrevocable and may not be changed by the survivor. Assets also held in the bypass trust do not receive a second step up in basis upon the surviving spouse's death. Whereas if you hold it all in the survivor's trust, then you do get a second step up in basis for community property. Another problem of having bypass trusts is you have to file a separate tax return every year, and the cost of administration and sub-trust funding is just more. So you're just spending more money. But as I said, most of the time we don't need this now because we have this portability election that started in 2012. And as I showed you in my example, is that you're able to pass on to the exemption to the extent it's not used by the decedent. The important thing to remember is that the portability election must be made within 9 months from the date of the first spouse's death, or you may receive a 6-month extension. You don't have to do the portability election, does not require a sub-funding of the trust, which is really great. So you can just do the portability, move everything over to the survivors, but you still get to use the unused exemption, and you've gotten to use theirs. So it's really, most of the time, it's just, you really just want to use portability. And especially now when the exemption amount's going down, we're going to see a lot more people who are going to need to file the 706 return to elect portability next year. So really the thing to remember with this, you don't have to remember this whole portability thing. You don't have to remember how to do it. The thing you need to do is after a spouse dies, you need to go see a lawyer who does estate planning, somebody who really does this all day long. Okay, so this is not the time you go and see the document preparer. This is not the time you go see the personal injury lawyer. This is the time you got to go find somebody that really does this all the time. And we are super lucky in this area to have so many good estate planning lawyers. Okay. Now, one of the things that we should just mention is that sometimes even when you have a revocable living trust and everything is going to the survivor, okay, so this is what we call the disclaimer trust. Here's the trust and everything goes to the survivor. But sometimes the survivor doesn't want it all. Sometimes they just feel it's best to, especially in a blended family, they'll want something to go over here and sit over by itself for the peace of the family. And this is called a disclaimer trust. It's only used if the surviving spouse elects to disclaim. And it's always, I should say always, but most of the time it's done to keep peace. So sometimes you'll see, even after the death of a second person, if someone was left out of a trust, a beneficiary was left out, or say one of the children passed away and the trust doesn't leave anything to the grandchildren of the child that passed away. The other children will say, oh, no, this is bad. You know, this isn't going to keep harmony in this family. So you'll see beneficiaries who will disclaim even after the second death. They'll disclaim their interest. But most of the time when people disclaim, it's because they're trying to keep peace. All right, so now we've talked about estate tax. So now we need to talk about the annual gift exclusion. So one of the best ways, especially if the exemption is going to go down and you have a taxable estate or close to a taxable estate, one of the great and easiest ways to transfer assets is the annual gift exclusion, which is $15,000 this year, and we expect it to remain $15,000 next year. So each one of us can give $15,000 per person to as many people as we want. And I don't know if you remember, but there was, I think it was George Clooney, one of those stars, had a big party and they invited, I don't know, 20 or 30 people. And they wrote out checks to $15,000 to each and every person who came to their party, because that's how much we can give and not have to do any gift tax return, and it's not taken off of our lifetime gifting. Okay, so I could give $15,000 to my daughter. I could give $15,000 to her husband. I could give $15,000 to my granddaughter. I'd really like to just give it all to her, but legally I can only give 15 to her, 15 to my daughter and her husband. My husband can do exactly the same thing. So we really could give $90,000 to them each year, and then we would be underneath the annual exclusion. And I'm sure they would really like that if we had it, but we don't, so we can't. Okay, so but that's for wealthy people. That's a great way to do it. Gifts that are in excess of the annual exclusion, you do need to file a 709 return. That's the gift return. And gifts in excess of the annual exclusion will reduce your lifetime estate exemption amount. So here's the example. I have many clients who come in and say, I want to give $500,000 to one of my children for a down payment on a house, which is crazy to me that that's the down payment, but that's the down payment on the house. And I say, that's no problem. We need to file the 709 return for you. And that $500,000 is going to be taken off of your lifetime exemption. So right now, the lifetime exemption this year is 11.7, but next year, it looks like it's going to go down to 6.2. So it's going to be taken off of whatever the exemption amount is at the time they die. Okay. And the IRS keeps track of the exemptions. And if you file 709 returns, which many people do, you want to keep those in your estate planning binder so someone can figure out how many gifts you made before you died. Okay, general rule is that any gift over the annual exclusion amount will reduce your estate tax exemption amount. However, the following gifts are not taxable and they don't count against your annual exclusion. And that is tuition that you pay or medical expenses you pay for someone else, as long as you pay them directly to the institution. So you could pay tuition to UCLA, Stanford, wherever. I don't think it covers books, and I don't think it covers, matter of fact, I'm positive it does not cover room and board. You can make unlimited gifts to your spouse. You can give gifts to a political organization as long as it meets the other requirements, and you can make gifts to charitable gifts. If you're going to make charitable gifts, it's a really great thing to make those charitable gifts from IRAs, because then you don't have to pay the tax, and you're giving a bigger gift to the charity. That's another talk, but there are great ways to really maximize what your IRAs and 401ks can do. So we are getting to another very interesting thing, and I see we have 10 minutes left. Taxes and your estate plan after Proposition 19. So as you probably all know, there was Prop 13, which set the property taxes in California at 1%, and then of the assessed value. And then it also adds plus what we call the bidders, or I shouldn't say bidders, but all the other things that come on. People who don't like them call them bidders. People who like them and like what they do, they call them just add-ons. So your property tax when someone dies, if it's community property, assets held as community property with the right of survivorship, or in a trust that's holding it as community property, will receive 2 full steps up in basis. The first step up in basis is upon the death of the first spouse. The second one is again upon the death of the second spouse. This has huge consequences for minimizing or eliminating capital gains tax for your beneficiaries. You want to check and make sure you do not hold assets as joint tenants, because joint tenancy by itself presumes that you only own 50%, whereas community property, it assumes you both own 100%. So community property, each of you owns the whole house. Okay, whereas joint tenancy presumes you each own half of the house. Now, sometimes if you've had this house forever, we're able to go back and prove that community property was actually used to purchase the house, and that at the time you purchased the house, community property with the right of survivorship was not available to you as a way to hold title, because we've only had that since 2001. But we would much rather have you put it into community property. So the step up in basis rules. Upon your death, your beneficiaries will still receive the step up in basis on your primary residence after Prop 19 and other real property that you own. Now, what assets do not get a step up in basis? Assets that are in a bypass trust do not get a step up in basis. US savings bonds do not get a step up in basis. Installment promissory notes do not get a step up in basis. Profit sharing plans do not get a step up in basis. And the biggest one is IRAs and 401k accounts and annuities do not get a step up in basis. And there is tax to be paid as they are withdrawn, assets are withdrawn. So let's just for a second talk about the problems if you try to gift during your life of real property. If you gift property during your life, you will be transferring the basis of that property to your children. Your basis when you bought the house, $50,000, you transfer it to your children during your life, they get your basis. Whereas if you gift the property after your death through either a trust, usually a trust, or even a will, your children will inherit your property with the stepped up basis. Your basis in this case, $25,000, value at death, $500,000. Your children now take the basis at the step up, $500,000. If you had tried to give it to them in this scenario, during your life, they'd have to pay capital gains on the difference between $25,000 and $500,000. Huge consequences. So let's just talk about the three basic parts of Prop 19 very quickly. Is Prop 19, like Prop 58 and Prop 60, still allows the transfer of property tax assessed value on your primary residence. It has to, again, be the parent to the child. It eliminated the parent-child on non-primary residence property. The important thing to know is that now the change is the transferee must use the property as their primary residence. So they have to move into the parent's primary residence. And there's a cap on the exclusion to $1 million of assessed value. So you get whatever the assessed value was of the property plus $1 million. Assuming you have a child who wishes to make your home their primary residence, it is going to be critical for you to have a first right of refusal in your trust to make sure your child will receive 100% of the property and therefore 100% of your assessed value, unless you have an only child. If you have an only child and you're leaving everything to them, then you don't have to do it. But if you have more than one child, it's critical that you have a first right of refusal so that they can take the whole property versus just 50%. In conclusion, it's very important to talk to your children to make sure they really want to live in that property. If they do want to live in the property, then to include the first right of refusal, to figure out what the fair market value is of the property. You can set the value if you want in the trust. So if there's some other reason that person's really been helping you and you want to give them a discount, that's something you can put in there. The other great part of Prop 19 was that you can move, and effective April 1st, 2021, you can move up to 3 times and from your primary residence and take your property assessed value with you. And that was the way that the legislature got people to vote for it, was people, lots of people wanted to move to a smaller place, downsize. This allows them to take the property with them to any county in the state of California, whereas before with Prop 58 and 60, we were limited to transfers. I think we were down to like 10 or 11 counties that would allow the transfers. So now we have all counties. So I want to thank you very much for having me here tonight. I know we have lots of questions. So Susan, if you want to tell me some questions, I'm happy to answer them.
Great. We do have a lot of questions, and I will start with the first one. So An attendee says, I have a trust, but it is old. The only thing in it really is my house. Can I get a notarized document to change my beneficiaries?
Absolutely, you can do that. I would highly recommend that you go and see an estate planning lawyer. So we kind of, for just a second, there are two ways that you can change your trust. You can amend it, okay, you can amend it, or you can restate it. Amend or restate. And the reason that amending your trust is absolutely fine if you're fine with everyone seeing the changes you make. So say you want to just change your trustees. You know, you have one child that moved far away, so you want to put the other child who lives closer to you as the new trustee, okay? Or you want to add beneficiaries. Maybe, you know, I want to give some money to a charity or a friend or something like that. However, if you're going to change beneficiaries, especially residuary beneficiaries, those are the people who are going to get all the money. It's much better for you to restate your trust, because if you restate your trust, they don't get to see what your old trust looked like. You get to have the same name. You don't have your property that's in the trust stays in the trust, but you change the terms of the trust, change all the terms of the trust. But the real value of restating your trust is that the people from before can't see what happened with the prior trust. And the reason we don't really want them to see is because a lot of times if people see that they were in a prior trust, they start arguing that the person was unduly influenced, and we just end up in litigation. So it's much, much better if you're changing your beneficiaries to spend a little bit more money and restate your trust.
And added on to that, what if your trust is not notarized? Is it still valid?
So that's a great question. It should be okay, but it's really become the custom in California to have your trust notarized. It's the way to ensure that someone independently has watched you sign your trust. So if your trust hasn't been notarized, I would go and have it notarized.
Okay. And there's a lot of questions about these trusts. What happens if you become incapacitated, but haven't updated the assets in the trust to reflect your current home and accounts?
Some lawyer will be happy. You'll make a lawyer happy. You know, it's so we don't really want to make lawyers happy. we really want you to minimize the time you spend with lawyers, even if you like the lawyers. But I really encourage you, if you know that you don't have, lots of times people come to me and come to other lawyers just because they need funding done. I mean, it's a common thing that people have had trust done at one of these trust mills where, you know, they just draft the trust, but they don't do the funding. And then people come to me and I do the funding.
Okay. So another person asks, can you have more than one living trust? Our house is partially owned by my wife's former brother-in-law. Can we establish a living trust for this one item and another living trust for all of our other assets which do not involve the brother-in-law?
Yes, people have lots of trusts. People have lots and lots of trusts. I don't encourage, so it sounds like for that situation, it probably is a good idea. If you're trying to manage a specific property, not only do you want to have a trust, but you probably should have some kind of tenant in common agreement as to the management of that specific property.
Okay, thank you. The next question, in the case of being single and having no children, am I correct to think that there would not be a step up in basis for nieces, nephews, siblings who would be inheriting?
Everyone gets a step up currently. So you don't have to be married to get a step up in basis. Your nieces and nephews will all get a step up in basis, and there'll be no tax to pay if they turn around and sell those properties, Or if they choose not to, then they would start at that new basis. They get the step up and then they would start from there and go up.
So, and another attendee is asking for advice. My wife and I are in our 80s. Relatives have advised us to deed our property to our children before the 5-year limit runs out to avoid losing our property as a result of the cost of a nursing home if one of us or both end up in a place for a long stay. Should we follow up on this advice?
Yes, you should go and see an estate planning lawyer. Now, so just so everyone knows, that's actually a great question, because up until about 5 years ago, we did have something that was called the Estate Recovery Act. And so that if you ended up being on Medi-Cal and you came under our safety net and you ended up being in a skilled nursing home or a SNF, they call them, after the death of the spouse, after you were both passed away, the state could come back, okay? But the law today is, as long as you have your house in a trust, there is no right to recovery by the state of California. That is huge. That is absolutely huge. So it would be much better for you not to deed that property, and much better for the beneficiaries, because if you deed it to them, remember, they're going to get your basis today or whatever you bought that property from, and they'll pay huge capital gains. Plus, you'll lose control of your own property, which is never a good idea. You know, those children, they can be grabby. Not mine, of course, but oh yeah, maybe.
An attendee says, my husband and I held our house in joint tenancy with rights of survivorship. I called the IRS and they said that this would be considered the same as community property in California.
Well,
there was not a community property designation when we bought the house.
Right. So the IRS is federal law, and the people who we care about more is the state of California. So yes, we can go back and try to, if it came up, we could go back and trace to make sure it was, but it's much cheaper for your beneficiaries to simply have it, and for yourself to ensure that you get a full step up in basis after the first death, is simply to have a deed done transferring it from from joint tenancy to community property with the right of survivorship.
And I think this is a clarifying question. Does community property placed in a trust stay community property? So when one spouse dies, I think, does the other get the step up in cost basis for 100% of the property?
Yes. And you said that very well, Susan. You're hired.
I'm reading. Two more questions. Somebody says, I was under the assumption that all will and trust lawyers also open a trust account. I am surprised to hear some do not. Can you please elaborate?
So when I was young and my hair was this color, that was a very common thing, that lawyers would open trust accounts and they would do the trust administration. Today, I'm not aware of any trust lawyers who do that. So today, when someone dies, I will shepherd them through how to open a trust account, but they must manage the trustees who are appointed successor trustees. They must do that. I will not manage. I will help. If there's finance issues, I'm happy to help people. Go to the CPA, go to the tax attorney, go to wherever we need to go to. But no, no.
And the last question, I think this goes back to when you were speaking about registering U.S. bonds. They ask if you can explain more about Treasury Direct.
So in the old days, many of us worked at places, even me in college, worked at places where you could buy savings bonds. A lot of times where they were EE savings bonds, and we bought them at a discount, and we ended up with a stack of them. Okay. And some people bought them at, $100, $1,000. I think they're $5,000 one. I mean, And so what happened was people just had them like in a safety deposit box, and then they die, and they've never, and they usually have them on like their spouse is the beneficiary. But the problem with that is that if you want to cash them in, if you have more than $166,250 worth of them, we have to probate it, okay? And even if you have less than that, there's this whole procedure. They make you write out all the serial numbers on every single one of them. It's mind-numbing. Whereas there's this great software now that Treasury Direct has, and you literally just go in and you put in yours, and they're logged in. And so you don't, and they're registered with them, and you can put new beneficiaries, you can put your estate, your trust, whatever you want to do, and it's 1,000,000 times better. Less attorney's fees.
Great. Well,
I don't like attorneys any more than anybody else. I'm always telling people, if I can teach you how to do it and you can do it yourself, I am happy.
well, thank you, Joan. Your presentation was so informative. I also want to thank all the people who attended tonight. Thank you all for joining us. I want you to know that if you've registered for this event, you will receive a link to the recorded video so you can go back and review, because Joan went over everything so quickly. And a copy of her presentation will be sent to you, and her contact info as well. If you enjoyed tonight's program and look forward to more, we invite you to make a gift to the Library Foundation on our website, and know that your gift makes a difference. We hope you'll return next Thursday for the last and final Finance 102 program, Investing During Uncertain Times, with Wealth Management Advisor Annalise Morris. More information and the registration link can be found on our website. Thank you again for attending, and have a good night.
Thank you.